On the 9th of January 2010, Charlie Cardoso stood outside a house in Spring Hill, Florida, and cut the padlocks off his own front door. He had paid $139,000 for it in cash 5 years earlier. There had never been a mortgage on it. Bank of America's crews had emptied it the previous summer and locked him out. And when the bank's own agent told them they had the wrong house, they carried on anyway. The house they meant to take was across the street, about 10 doors down. But nobody caught the mistake, because catching it would have meant reading something. And in those same months, outside Philadelphia, one man was signing 10,000 sworn court documents a month, and he was about to testify under oath that he did not read them. What happened to that one house happened in some form to a country. More than 1 million sworn documents manufactured by a single company in Georgia, filed in courthouses in every state, and no one has ever counted how many families lost a home because of them. New Bedford, Massachusetts, 2005. It starts with a couple buying somewhere to retire to. Charlie and Maria Cardoso lived in New Bedford, Massachusetts, a fishing city on the South Coast. In March 2005, they bought a 3-bedroom house with a pool at 9168 Geneva Street in Spring Hill, on the Gulf side of Florida, a few blocks south of Spring Hill Drive, in the kind of tidy subdivision where every house has the same porch posts and a different number. They paid $139,000 for it. They paid it in cash. It was Charlie's life savings. That word does a lot of work, so it is worth being precise about it. When the Cardosos paid cash, no lender was involved. Nobody held a lien on the place. There was no loan to fall behind on, no monthly payment, and no note that anybody could sell to anybody else. What they got instead was a deed, signed at a closing table, and then carried into the Hernando County Recorder's office and stamped by a clerk. Anyone in Florida could have walked into that building, asked at the counter, and been shown who owned 9168 Geneva Street. It was on the record in the most literal sense this country has. The Cardosos rented the house out while they waited to retire into it. And in late June 2009, their tenant telephoned in a panic. 3 men from Bank of America were at the property to foreclose on it. They cleaned the house out and padlocked the doors. Now when a bank forecloses properly, it is collecting a debt. It sells the house, takes what it is owed, and hands the rest back to the owner. That is what makes it a debt and not a seizure. But all of that depends on there being a debt, and there was no debt. Charlie Cardoso got one of them on the phone and told him, in the plainest words available, that he had no loan with Bank of America, that he had never had a loan with Countrywide, which Bank of America had bought the year before, and that he owned the house free and clear. He asked the man to please double-check. Then something happened that ought to have ended it in an afternoon. The real estate agent that Bank of America itself had hired to handle the property contacted the bank to tell it that it was foreclosing on the wrong home. Not the homeowner. Not the homeowner's lawyer. The bank's own agent, inside the bank's own process, saying the address was wrong. The Cardoso's attorney later put it to a reporter this way. Their own real estate agent told them, and nevertheless, Bank of America steamrolled right ahead. In August, a landscaping crew working for the bank broke the fence to get their mowers into the yard. Just before Christmas, the tenant, who had been frightened out of the place, moved out for good. And on the 5th of January 2010, Bank of America's people came back and padlocked the house again. On that 5th of January, Charlie Cardoso got through to a representative who checked the file and told him something that should have been the end of it. She said the bank had made a mistake. She said someone would call him back within the hour. Nobody ever called him back. Not that day and not on any day after it. So on the 7th of January, his son put him in a car and drove him from Massachusetts to Florida, 1,300 miles, because there was no longer any other way to be heard. He was not at the airport that week. Maria's son was coming home from his 3rd tour in Iraq, and Charlie Cardoso missed the homecoming because he was on an interstate going south to argue with a padlock. On the 9th of January, the police finally agreed to let him into his own house. He drove to a hardware store, bought a bolt cutter, came back and cut every lock off the doors, and then had to break in through the back screen door to get inside. The pipes had frozen because the water and power had been shut off. The pool pump was dead. The lawn had brown patches where the sprinkler system had failed, and tire tracks across it where a truck had driven over the grass. Almost everything they owned was gone. The air compressor, the nail gun, the table saw, the lawnmower, 2 refrigerators, the gas grill, and the family photographs. The only things left were in the attic, which the crews had apparently not found. On the 20th of January 2010, the Cardosos filed suit in federal court in Massachusetts. The bank's spokesman gave the press a sentence that has been given to every wronged customer in history. The company had reached out to their representatives and hoped to have the opportunity to properly assess and address their allegations. That story sits inside a much larger number. In 2010 alone, roughly 1.2 million American homes completed foreclosure. That was the peak year of the worst wave of home loss since the Depression, and in September of that year alone, about 120,000 foreclosures were completed. Every one of them was, at bottom, a paperwork event. Somebody produced a document asserting who owned the loan and how far behind the borrower was, and somebody else acted on it. Which raises the only question that matters in this film. And it is not a question about mortgages. It is a question about reading. Because the Cardosos were not defeated by a computer, or by a policy, or by a bad decision made in a meeting. 6 separate times a human being at that bank had the opportunity to open a file and check an address, and no human being did. The tenant told them. The owner told them. Their own agent told them. And the machine went on producing documents about a house it had never looked at, because the documents were not being produced by anyone who looked at anything. To understand how that was possible, you have to know what the piece of paper at the center of a foreclosure actually is, and what it promises and who is supposed to have read it. To take a house through a court, a bank has to hand a judge a piece of paper, and the paper has to be sworn. It is called an affidavit, and it is one of the oldest devices in the legal system. A judge cannot examine every mortgage in America. So the law lets one person swear, on penalty of perjury, that they have looked at the file, that they personally know what the loan is, who holds it, what is owed, and how far behind the borrower has fallen. The judge is not trusting the bank. The judge is trusting that one named human being sat down with the documents, read them, and is prepared to go to prison if they are lying. The phrase carrying all of that weight is 4 words long. Personal knowledge of the facts. The person swearing does not have to be important. Usually they are not. They have to be real, and they have to have read it. That is the whole mechanism, and it is thinner than it sounds because in a foreclosure hearing, there is very often nobody in the room to argue back. Most homeowners in foreclosure have no lawyer. Many never appear at all. The affidavit is not one piece of evidence among several. In a great many cases, it is the only evidence. The hearing takes a few minutes, and then a house belongs to somebody else. So the entire structure rests on a question nobody had thought to ask out loud. Does the person who signs actually read them? On the 10th of December 2009 in West Palm Beach, Florida, a lawyer named Christopher Immel put that question to a man named Jeffrey Steffen. Steffen worked for GMAC Mortgage in Fort Washington, Pennsylvania. He was not an executive, and he was not a lawyer. His title was team leader of the Document Execution Unit, and his unit had 14 people in it. Under oath, Immel asked him how many documents came to him to sign. In a month, Steffen said, my team brings to me approximately, I'd say a round number of 10,000. That's just an estimate, of course. 10,000 a month. A working month at 8 hours a day contains about 10,000 minutes. He was not asked to do the arithmetic, and he did not do it. Asked directly how long he spent on each document, he said only that it was tough to say. Then Immel asked the question the whole system rests on. So these documents wouldn't be actually executed on your own personal knowledge? Right, Steffen said. There is more, and it gets worse in the specific way that only procedure can. The notaries who certified that Jeffrey Steffen had appeared before them and signed were not, he confirmed, physically present. In one instance in the record, he executed an assignment on the 3rd of March, and a notary certified it on the 4th, and he agreed that this was common. Nobody in his unit went into the system to verify that the figures were accurate. They relied, he said, on the attorney network that sent the documents in. 6 months later, on the 7th of June 2010, a Maine lawyer named Thomas Cox deposed him again in a second case and got the rest of it on the record. 400 documents a day. Do you read every paragraph of a summary judgment affidavit before you sign it? No. What do you read? I look for the figures. Do you inspect the exhibits attached to it? No. So you do not appear before the notary, is that correct? I do not. To be fair to the man, he did check something. He looked at the numbers against his employer's own computer system, though not, he said, down to the penny. What he did not do was read the sentence directly above his signature, the one that said he knew these facts personally. The Maine court did not treat that as a technicality. It found the affidavit had been submitted in bad faith and ordered the plaintiff to pay nearly $24,000 in the homeowner's costs. When the case reached Maine's highest court, the judges wrote a sentence that ought to have been the end of the practice in the United States. The affidavit in this case, they said, is a disturbing example of a reprehensible practice. That such fraudulent evidentiary filings are being submitted to courts is both violative of the rules of court and ethically indefensible. And in the same opinion, in a dissent, a judge noted something that removes the last possible excuse. 4 years earlier, in 2006, a Florida court had sanctioned the very same company for the very same practice. It had been caught. It had been told. Nothing had changed. Because by then it was no longer one tired man at one desk. It had become an industry. There was a building where this was done at scale, and it looked like nothing. A low-rise office suite in an industrial park in Alpharetta, Georgia. The company inside was called DocX. It was owned by Lender Processing Services, a publicly traded corporation headquartered in Jacksonville, Florida, and its business was executing the paperwork that moved American mortgages from one owner to another. Between March 2003 and late 2009, according to the United States Department of Justice, DocX produced more than 1 million fraudulently signed and notarized mortgage documents and filed them with property recorders' offices across the country. Over those 6 years, it took in about $60 million in revenue. One name appears on those documents more than any other, and the woman it belongs to did nothing wrong. Linda Green was real. In 2003, she was a shipping clerk for auto parts when her grandson told her about a job at a company called DocX. She told CBS she had never been a bank vice president. DocX made her one anyway, a vice president of institutions she had never set foot in. And the reason it chose her, she said, was that her name was short and easy to spell. Then as the work piled up, Docs needed more of her. Her name went on to hundreds of thousands of mortgage assignments in a dozen different hands, and she was never charged with anything because the hands were not hers. One of them belonged to a man named Chris Penley. In April 2011, he sat down with Scott Pelley of 60 Minutes and explained it without embarrassment, because nobody at DocX had ever told him it was wrong. "So you're Linda Green?" Pelley asked him. "Yeah," Penley said. "Can't you tell?" He had been hired to sign documents using someone else's name. That was the job as it was described to him on his first day. He thought it was strange, and he said so, and he was told repeatedly that everything was above board and legal. The qualification for the position was that you had to be able to hold a pen. He was paid $10 an hour. The floor quota was 350 signatures an hour. Penley estimates he alone did 4,000 a day. Asked how many banks he was a vice president of on any given day, he answered, somewhere around 5 to 6. There is a second person in that broadcast, and she is the one who closes the circuit. Shawana Cright also worked at DocX, and she was also a Linda Green. She signed and she notarized. So if Chris Penley was signing for Linda Green, Pelley asked her, "You'd notarize that document?" "Yes," she said. A notary's entire function is to attest that a named person appeared before them and signed. At DocX, the notary was at the next desk, certifying a signature she had just watched somebody else invent. You do not have to take a television program's word for it. The Florida Attorney General's Economic Crimes Division built a presentation on foreclosure filings, 98 pages, and put 5 slides in a row under one heading. Variations of the Linda Green signature. 5 scanned assignments, 5 different hands, 1 claimed name, each of them stamped vice president. The deck's own summary of what it was looking at ran, thousands and thousands and thousands of assignments signed weekly. A Florida investigator named Lynn Simoniak, going through her own foreclosure file, found the name Linda Green signed as vice president of 20 banks at the same time. And here is the part that makes it a public matter rather than an office scandal. Every one of those pages was filed with a county recorder. A recorder's office is the ledger of who owns what in America, the place a stranger goes to find out whether a house is yours. Once a document is recorded, it is public truth. The factory was not producing paperwork. It was producing title. The machine ran until an official of Bank of America gave a deposition in which she said she signed 7,000 to 8,000 foreclosure documents a month without reading them. Then it stopped very fast. On the 20th of September 2010, GMAC Mortgage told its brokers and agents to halt evictions in 23 states. On the 29th, JP Morgan Chase suspended more than 50,000 foreclosures. On the 1st of October, Bank of America froze foreclosures in the same 23 states, saying it needed to amend all affidavits in cases that had not yet gone to judgment. On the 8th of October, it extended that freeze to all 50. The number 23 is the whole reason any of this ever surfaced. In 23 American states, Florida, New York, New Jersey, Illinois among them, a foreclosure has to go through a court, and a judge has to be handed a sworn statement. In the other 27, a bank can take a house without ever showing a judge a piece of paper. The paperwork was only ever inspected where somebody was legally required to look at it. On the 13th of October 2010, attorneys general from all 50 states announced a joint investigation. 17 days after it stopped, it started again. On the 18th of October, Bank of America announced its review was complete and that it would process affidavits in 102,000 proceedings. On the 27th, Wells Fargo said it would file supplemental affidavits in 55,000 foreclosure actions. Nobody had gone back through the files. They had re-signed them. The reckoning arrived on the 9th of February 2012. $25 billion. The Justice Department, the Department of Housing and Urban Development, 49 state attorneys general and the District of Columbia, every state except Oklahoma, against the 5 biggest servicers in the country, Bank of America, JP Morgan Chase, Wells Fargo, Citigroup, and Ally, which used to be GMAC. This agreement, the Attorney General said, is the result of unprecedented coordination among enforcement agencies throughout the government. Now take the number apart because the number is the story. 20 billion of the 25 was consumer relief, principal written down, loans refinanced, credits the banks earned by doing things to loans they still held. 5 billion was other payments. And inside that 5 billion sat one fund of $1.5 billion. And that fund was the only part of the 25 billion that was cash in an envelope to a person whose house had already been taken. 1.5 of 25, 6%. The checks went out in the second week of June 2013. 962,278 valid claims, $1,480 each. More people came forward than anyone had planned for, which is its own finding. The settlement had been sized for about $750,000. Alongside the settlement ran a second remedy, and it failed differently. On the 13th of April 2011, federal regulators issued consent orders against 14 banking organizations and separate orders against lender processing services and the electronic registry that tracked who owned which mortgage. The regulators' finding was a pattern of misconduct and negligence related to deficient practices in residential mortgage loan servicing and foreclosure processing. The remedy was called the Independent Foreclosure Review. Outside consultants would open every foreclosure file from 2009 and 2010 and find out who had actually been harmed. They never finished. On the 7th of January 2013, the review was terminated and replaced with a payment. By the time it was canceled, servicers had completed final reviews on about 14% of the files slated for review, and not one consultant had finished their sample. The reason given was arithmetic. Regulators were told that finishing would cost at least $2 billion more in consultants' fees, and that the reviews themselves would return roughly $1.2 billion to the people who had been harmed. It would have cost more to find out who was hurt than to pay them. So they stopped looking and started paying, and everybody got the same thing whether or not anything had been done to them. The Federal Reserve's own final report says it plainly. The servicers were required to make cash payments to all borrowers whose homes were in the foreclosure process during 2009 or 2010, regardless of whether the borrower had suffered financial injury caused by servicer error. Here is what that produced. The Federal Reserve published the payment table on the 9th of April 2013. Add up every category paid at the bottom rate, and you get 2,358,441 people out of 3.9 million in the table who received $300, 59.7% of them. At the other end, 1,082 borrowers received $125,000, and every one of those was a service member whose home had been foreclosed in breach of a law written specifically to protect people on active duty. Then the checks started coming back. On the 17th of April 2013, the Federal Reserve confirmed that people who had received early checks were calling its consumer helpline to say they had been told the checks could not be cashed. The paying agent fixed it. Nobody has ever published how many bounced. What is on the record is a separate error. About 96,000 checks were issued for less than the borrower was owed and were corrected 2 months later. And that is where the counting stopped for good. There is no number anywhere for how many American foreclosures rested on documents that were manufactured. Not because nobody asked, because the only mechanism ever built to find out was switched off with the reviews unfinished on some 86% of the files. The criminal reckoning is one sentence long. Exactly one person went to federal prison over any of it. Others were charged. In Nevada, the Attorney General charged 2 title officers on 606 counts, and in February 2013, a judge threw the entire indictment out from the bench, citing prosecutorial misconduct in the grand jury. Neither of them was ever tried again. Lorraine Brown, the chief executive of Padlocked, pleaded guilty on the 20th of November 2012 to conspiracy to commit mail and wire fraud. And on the 25th of June 2013, a federal judge in Jacksonville sentenced her to 5 years in prison, 2 years of supervised release, and a $15,000 fine. Her company did not go to prison. 4 months before she was sentenced, Lender Processing Services signed a non-prosecution agreement and paid $35 million. Missouri charged her too, and that case did not begin with a regulator. It began with a county recorder of deeds in Boone County named Betty Johnson, who searched her own filing system for documents signed with the name Linda Green and found them. 2 households in this story got something back, and both of them had to go and take it. In Naples, Florida, a couple named Warren and Maureen Yurgis bought a house for $165,000 in cash. They bought it from Bank of America because Bank of America owned it, because Bank of America had foreclosed on it. About 4 months later, Bank of America served them with foreclosure papers on the house they had just bought from Bank of America, with no mortgage on it from a bank that had been the seller. It took 18 months to make it go away. The case was dismissed and a Collier County judge ordered the bank to pay their legal costs. The bank did not pay. So on a Friday morning in June 2011, their lawyer, Todd Allen, walked into a Bank of America branch on Davis Boulevard in Naples with sheriff's deputies in a moving truck and announced that he was there to foreclose on the bank. Within an hour, the branch manager had written a check for $5,772.88. When the bank later apologized in writing, it misspelled their name. And Charlie and Maria Cardoso. The bolt cutter in the back screen door got him into the house on the 9th of January 2010, but the argument took another 15 months. In April 2011, Bank of America settled with them. The terms were never made public, and neither side has ever discussed them. What is on the public record is only this. 9168 Geneva Street was theirs the entire time, in the county's own filing cabinet, in a document anyone could have walked in and read. It took a federal lawsuit to get a bank to agree with it. And the paper from those years is not finished with people yet, which is where this stops being history. So finish the count. Roughly 7.8 million completed foreclosures in the United States between 2007 and 2016 on CoreLogic's count. More than 1 million documents produced by one company in Georgia, signed by people who had never read them, and notarized by people sitting next to them. $25 billion announced, of which $1.5 billion was cash to people who had lost a house. $1,480 each. 2.36 million people paid $300. One person in a federal prison. And no number at all, not an estimate, not a range, For how many families lost a house on paperwork that was manufactured because the country stopped counting before it knew? The paper is moving again. Between 2006 and 2008, the head of the Consumer Financial Protection Bureau said in 2023, foreclosure filings in America rose threefold, from 700,000 to 2.3 million. Many of the second mortgages written in those years went quiet, were written off, and were sold to debt collectors for pennies on the dollar. Now the collectors are back, and the Bureau's phrase for them is zombie second mortgages. Loans most homeowners last paid in 2015 or earlier, on which interest and fees have been running the whole time, arriving as a foreclosure threat 2 decades after the ink dried. In January 2025, the Bureau found that one or more companies had failed to send those homeowners the statements the law requires. A class action filed in Massachusetts alleges a servicer and a trustee failed, as a matter of systematic internal policy, to send billing statements to borrowers whose second mortgages had been discharged in bankruptcy, and then moved to foreclose. And since February 2025, in the Government Accountability Office's own words, the agency that wrote those findings has been reducing the size and scope of its activities and staffing. Its funding cap was cut in half by statute in July 2025. It has issued stop work orders, closed supervisory examinations, and terminated enforcement cases. Reduction in force notices went to the overwhelming majority of its staff. A plan a federal court has so far blocked, and which is still in litigation as this film goes out. Somewhere tomorrow morning, a page will be signed by someone who has not read it, and a county recorder will stamp it, and it will become true. That is not a prediction. That is how the system is designed to work, and it worked exactly as designed the last time, which is the part nobody has ever fixed. If you think a house somebody paid for in full should not be able to disappear into a filing error, and that when it does, somebody should have to count how many times it happened, hit like so the next story like this one gets told while the paperwork is still on the counter.